My name is Patrick Keene, and our panel is entitled FRAND, Standard Essential Patents and Figuring Out the Larger Picture. So I have a very esteemed set of panelists here with us today. All of us have experience in building strong IP portfolios and engaging in transactions associated with those portfolios. I think it's very important going forward that you have a good sense of how strong your portfolio is. We need better practices to improve the strength of these portfolios, but you also have to have an eye in building these portfolios toward the ultimate use of them as leverage in this world of convergence where standard essential patents, FRAND, and all transactional aspects of intellectual property are becoming so important. So again, this panel has great experience in all of these areas. I'm going to give a brief introduction. To my immediate left is Dr. Sheetal Chopra. Sheetal is with Ericsson. She is the General Manager and India Lead for IPR Advocacy, IPR Policy, and Communications, with focus, among many things, on patents and patent licensing and participation in policy forums on behalf of Ericsson and so forth. So we're very pleased to have Sheetal with us. And then to Sheetal's left is Dr. Stefan Shohei from the law firm of Beaumont and Beaumont. And Stefan is a German and European patent attorney. He's based in Munich. He's very active in the field of IT, computer-related inventions. Again, building strong IP portfolios that can withstand challenge before IPOs and serve as leverage in IPR negotiations. To my right is Sanjeev Tiwari from K&S Partners in India. He leads the patent and design litigation practice for the firm, again, specializing in enforcement, protection, and dispute resolution in all areas of IPR. As I mentioned at the onset, he also is very experienced in transactional matters, technology transfer, licensing agreements, and so forth, exploiting IP and building IP to withstand the challenges of today's marketplace. And then to Sanjeev's right is our fourth panel member, Deepak Srinivas, from the firm of LexOrbis, where he heads the patent engineering group, specializes in drafting, filing, prosecuting patent applications, and advising on strategic use of IPR in global markets. So that's our panel, and we thought we would begin by giving a brief overview of the current state of affairs regarding SEP and transactional aspects. We have the benefit with this panel of, I'm as moderator from North America, US. We also have a great wealth of knowledge here on Asia and India in particular. And then with Stefan, we have a European perspective. So I think we can provide a nice summary of the current status of things globally for you. And then just identifying the issues at that point, that's number one. And then number two, we'll drill down on specific issues because, as you know, I'm sure many of you are aware, this SEP FRAND issue is gigantic in the global marketplace right now, and the many, many issues that surround this. So I'm going to start with this brief overview, number one. And I will ask Stefan if you wouldn't mind to start off with some discussion of current trends in Europe generally, and then we'll turn to India, and then I'll give a wrap-up of US before we move to a drill down. Stefan?
Well, thank you, Patrick, for the introduction. As you may know, Europe and especially Germany was one of the epicenters of the smartphone wars, and probably still is. And inevitably, the issue of standard essential patents and FRAND came up in litigation. Why is this? Because we have case law that, in a nutshell, says if you are controlling standard by patent and thereby you have a market dominant position, the user of the technology, or in this case, the defendant, has a right to a license. Not a free license, but a license to friend conditions. That was established probably 5 or 6 years ago. But then the question is, well, obviously not everybody should be a free rider on technology, and there were basically two positions. One was the German courts that said, well, if you are the defendant, if you are the evil infringer, so to speak, and exceptionally we let you off the hook by not granting an injunction, you really have to behave like a proper licensee, so you have to make a friend offer, you have to abide to all provisions of the contract, even in anticipation of the conclusion of the contract. And that, of course, was a great burden. And guess what happened? Defendant said, my offer is friend. The patentee said, well, your offer is not friend. The court stood in the middle and said, well, we don't know, but the defendant hasn't made its case, and hence we can't injunction. So that never worked. The counterpart was the EU Commission, which in a procedure against Samsung took the position, well, it's just sufficient to be a willing licensee to avoid an injunction, and that was rightly criticized, as it gives rise to what is called reverse hold-up. You pretend you're willing, but you track out negotiations, and ultimately, and so that the patent cannot be enforced against you, and that could not be right either. The thing went up to the ECJ to get to the latest developments. The ECJ ruled in its wisdom some middle ground. Basically, there are 3 criteria. First, the patentee has to give notice of the infringement. Second, the patentee has to start the licensing process by making a friend offer, and to which then the defendant has to reply either by accepting it or making a counter offer, which again should be friend. The court ruled also, which was disputed before, that in litigation you can challenge the validity of the patent, and you can also challenge that you're using the patent at all, which some German courts held before was not allowable. And then there was a proviso with the whole decision that all this only applies if indeed the standard grants a market dominant position. People said this is a nice decision, it takes some middle ground. The problem is, of course, how to apply it, as usual, when we get something handed down from the ECJ. And there were 3 conclusions drawn, maybe more, from this decision. The one was, okay, the ECJ only talked about dominant position, so the courts will first assess, is friend an issue at all? If the standard does not establish a dominant position, we don't even have a case, and we grant our injunction. So that's the easy thing. And there are standards that don't establish a dominant position because there are alternative technologies that are accepted in the market, or the standard has not been established to that extent that it establishes dominant position. The more interesting thing is, well, what about the notice to the infringer? And there are 2 schools of thought. The one school says, well, this actually means that has to be pre-litigation. Because the idea is, and that has some reason to it, things should be like in a normal negotiation. And if you only make your negotiations while litigation is pending, that's of course under pressure for the defendant to conclude a licensing agreement, because the clock is ticking, and after 15